But that's not true.
Yes.
Wait, please, my lords. Because I am done largely. I have a little bit to add only. Your lordship has seen STC. So I'm not repeating it. Lordship will just connect with the last time. My lords will notes will connect it.
Yes, yes, yes. Whereas page 35 of STC you were referring.
That your lordship is done with this because STC broadly your lordship has seen. That's your lordship ended. I will only suggest that your lordships, I've given the references of the Ayatollah, went into some detail. And then the conclusions are at 41, 42.
This STC.
Yes. Which are need not be read, your lordship will just note that bottom page. What is this page? This one. 41 of the PDF. At the very end. The whole judgment has the entire jurisprudence summarized by Justice Ayatollah. It's a useful summary, but I'm not troubling the lordship with all that.
41.
Yeah. Is it 41? Will you tell the page? With all this. This is not the way to assist. Well, this SCC online page I am referring to is
Page 41.
Give me a minute. I don't know why you're here. This, where is this page? There are not even pages here. The beauty.
Page 39.
Where is page 39 bottom? Your head was this here? Should be here. At the bottom, just keep it here. I am therefore of the opinion that the State Trading Corporation cannot be regarded as a citizen for the purpose of enforcing rights under Article 19(1) F and G. The last line. Going on to the next page.
41.
Yes. No, but it's 39 bottom. Your lordship printed page on top is 39. I mean the typed page or printed page.
Yes.
Last line.
I am therefore of the opinion.
Yes, yes. And then was okay, keep doing this. Then was this is followed by a constitutional bench in Telco. And for that, your lordship in turn to do this. This was
73. Page 73. Yes.
Yes. Mr. Sibal read 85 and 86. I want to read. I'm not going to repeat scrupulously anything. I want to read the previous page. Printed page 84. On the top central page 84. It's also constitutional bench. Well, this the STC is a very respectable lineage. And therefore, one of it has been followed in several cases. I'm just showing some of the major ones which follows it on this point.
Yes. Which page you are referring?
84 is the printed page. 84. Why are you saying that? Just keep it like that. That being the position, does my lord have it?
Yes, yes.
That being the position with regard to the doctrine of the veil of a corporation, the principle of the said veil can be lifted in some cases. The question arises for our decision is, can we lift the veil of the petitioner and say that it is the shareholders who are really moving the court under 32, and so the existence of the legal and juristic separate entity of the petitioner as a corporation or as a company should not make the petitions filed by them under 32 incompetent. We do not think we can answer this question in the affirmative, but there's a double negative there. They are saying it can't be maintained. In a simple language, the triple negative in fact. No doubt the complaint made by the petitioners is that the legal can be achieved by them indirectly by relying upon the doctrine of lifting of the veil. So you can't maintain a petition otherwise, but you lift the veil and say it's nothing but the government. If the corporations and companies are not citizens, it means that the Constitution intended that they should not get the benefit of 19. It is no doubt suggested by the petitioners, though Article 19 is confined to citizens, the Constitution makers may have thought. It is no doubt suggested by the petitioners. One of the petitioners said, please hold it maintainable. So they are dealing with that argument. it is no doubt suggested by the petitioners that though Article 19 is confined to citizens, the constitution makers may have thought that in dealing with the claims of corporations to invoke the provisions of 19, courts would act upon the doctrine of lifting the veil and would not treat the attempts of the corporations that behalf is falling outside 19. We do not think this argument is well founded. The effect of confining 19 to citizens as distinguished from persons to whom other articles like 14 apply clearly must be that it is only citizens to whom the rights under 19 are guaranteed. If the legislature intends that the benefit of 19 should be made available to the corporations, not be difficult for it to adopt a proper measure in their behalf by enlarging the definition of citizens prescribed by the Citizenship Act passed by Parliament. On the other hand, the fact that Parliament has not chosen to make any such provision indicates that it was not the intention of Parliament to treat corporations as citizens. Therefore, it seems to us the view of the distinguished court in the case of STC. The petitioners cannot be heard to say that their shareholders should be allowed to file the present petition on the ground that in substance, the corporations are nothing more than associations of shareholders. Whereas the next para has been read. It's important. Just underline where Lordship should read and I will not read because it has been read at the bottom of this page. Below that judgment of All India Banks Industrial. That's also important and that I will treat as having been read to save time. Then, Willis, this is followed by yet another constitution bench at page 88. The third constitution bench. British India Steamship. Only one passage at 91. Starts in it is short judgment. Besides, it appears at 91, Willis, that these writs purport to raise a question about validity of 52A of the Sea Customs Act may have weighed in favor of equity in the matters. But as we have held in Civil Appeal 770, the foreign companies whose vessels have contravened the 52A, on which penalties have been imposed, are not entitled to claim the fundamental right. Now, this is true, it's a foreign issue. But I'm just saying, maintain with citizens alone, not foreign, not corporations, not departments. In regard to the shipping costs, there are two categories. The previous para was foreign. This is now in regard to the shipping corporation, which was filed 3 writs. The said corporation is in no better position. As a result of the decision in STC, the shipping corporation cannot claim to be, etc., a citizen not entitled to upon Article 9. Whereas Barium, a case which is very celebrated at page 92, is celebrated for the other point by Lord knows well, relevant considerations, irrelevant considerations, etc. But there is in that celebrated case a para on STC also at 103. It is not cited for that purpose so much, but it is at 103. As already stated, the appellant had challenged the provisions of I'm sorry, I'm very
Just 1 minute.
I'm sorry. As already stated, the appellant had challenged the provisions of 237. That is one of the inquiry by the inspector on which your lordship had the famous laying down of law, etc. That was the old law.
Yes.
Sorry, my lord, it starts at 90.
103.
At 103. Sanjari has got it?
Yes.
As already stated, the appellant had challenged the provisions of 237 on the ground that they are violating the fundamental rights under 14 and 19. Our brother Shellett has dealt with this attack in the provisions fully, and we agree with him generally with what he has said while dealing with the contention. However, I'd like to add, the company being an artificial legal person cannot, as held by STC, claim the benefit of the provision of 19(1)(g). It applies to department equally. Through appellant 2. We agree with our learned brother that the action proposed under so-and-so being really exploratory, the fundamental rights to carry on with this, that's a separate issue. That's a separate. Which is the main juristically elaborate judgment. Makes it clear that they are not entitled to, the corporations or departments are not entitled to, I'm summarizing this, the rights of natural persons who must be citizens. Now, Willis, Articles 21, 22, and 14 have been invoked by ED. I'm just summarizing. The Lordship knows this point, but no doubt invoked. Willis, either ED has a 14, 21, 22, which even they don't contain. I am ED, Willis, this is ED. ED itself can't contain that I have 14, 21, 22 on this. The second contention is I am the officer of ED and I have that other officer petition. Well, it is clear, and this is important. You cannot do indirectly what you can't do directly. Now, that officer petition is nothing but nothing at all. That officer has no existence, no identity, no nothing except as a person discharging the duties under the statute, is my humble submission to my lord. He is acting as a person discharging his statutory duties. In that, he is representing, acting for, in accordance with or not in accordance with a different question, the statutory provisions. So that's my answer always to that
No,
petition.
this directly, indirectly principle,
Yes.
whether it applies to administrative law or it applies to for maintaining a petition for breach of fundamental right also.
Yes. I'm very grateful for the query.
Yes,
Well, my humble submission applies to both.
yes.
This principle of what you cannot do directly, you cannot do indirectly, is what I might submit, is only well as your lordship is to consider making a submission, is a subject neutral principle. It's a subject neutral principle. So, brothers, if this cannot be done by this path, if I am able to show, obviously I have to show that, otherwise it won't work, that the alternative path is nothing but a camouflaged version of the same path, then your lordship will apply the principle, subject neutral. Public law, private law, this is a principle of equity. Well, for example, your lordship has another principle of equity, cannot take advantage of own wrong. I'm just giving an example. There is a judgment called Priyanka, which very deep. Third principle, you cannot say X and directly in the next sentence or the next paragraph or the next case before the same bench say Y, the opposite. These principles, very important query from my lord's submission, I'm answering this to the best of my ability, apply subject neutral. They don't apply in administrative law, disapply in contract, reapply in tort, and then again not apply in constitutional law. These are equitable principles meant for safeguarding the court
Subject neutral and rights neutral also.
It's new across, absolutely. I mean, I cannot make a selective. If it applies, obviously, factual inquiry the judge makes, whether it applies or not, is the judge's prerogative. Your lordship may say this path A is not a camouflage to be. That's the answer on facts. But the moment your lordship comes to a finding that substantively the attempt is to reach the same goal by a camouflage, by an embellishment, by something or the other, we all know that, then my answer can't be selected. To my lord's straight answer, the question, the answer has to be straight. That it will apply across. You call it rights, you call it liabilities, you call it duties, you call it subject. It has to. Otherwise, your lordships, these are self-protective, equitable principles. For example, the government says you do this, I do this, and the government then penalizes, taking advantage of your own wrong. Another principle, law cannot compel me to do the impossible. Department X says do this, Department Y penalizes me for doing that, etc., etc. These are, the lordship rightly puts it, rights neutral, subject neutral, principle neutral, case neutral, if they apply, if they arise. Now, therefore, this is, and also lastly, they raise 14. So 21, 22 I've dealt with. ED raises 14 also. 14, arbitrariness and inequality neither arises for either the officer acting in the discharge of his duties nor for the department. That's simple. 14 is either the classification doctrine of equality or the doctrine of some arbitrariness. Now, of course, the lordship has gone in those Joseph Stein and all those cases into substantive due process, etc. Mainly. None of them arise for an ED department or for an officer in this case. Then, there is one case, very old, venerated case, which I want to, it's really one of the first, those Article 14 cases, Part 3 cases. That's Charanjit at page 537. Is it printed 537? Same volume? Yeah. Your lordship, same volume, 537. Please come with it. Very nice to know that 1950 is now supplied by SCC.
Yes.
Lordship will never get this title on any case. You'll always look at SCRs or AIR.
But the only difficulty is paragraphs are missing.
That's true. That will change. Charanjit was actually the first case after the functioning of the Republic was of a major kind in terms of this article. This was the doctrine of classification, is known for that.
Yes.
Now, if your lordship comes to para 13, which is at 563, I'm only reading some portions for my point, because I'm not going to be, it's a very detailed judgment, because those days the law was not developed. Article 14 is literally a baby. The application, I'm interested was from placitum B.
563.
Yes, the relevant part, para 13. I'm interested from placitum above placitum B, but I will read the whole para for completeness.
Yes.
The application before us under 32 is on behalf of an individual shareholder of the company. 32, as its provision show, is not directly concerned with determination of constitutional validity of particular enactments. What it aims at is the enforcing of fundamental rights guaranteed by the Constitution, no matter whether the necessity for such enforcement arises out of an action of the executive or the legislature. Now, this is the part you should be considered emphasizing as far as I am concerned. To make out a case under this article, it is incumbent upon the petitioner to establish not merely that the law complained of is beyond the competence of the particular legislature as not being covered. So that's the legislative competence test, the noun validity. But that it affects or invades his, mark the word his, fundamental rights guaranteed. That's the word his, of which he, again he, could seek enforcement in an appropriate writ. The rights that could be enforced under 32 must ordinarily be the rights of the petitioner himself. Well, one exception is PIL. Lordship has everything. It's not that a lordship is without any remedy or without power. The lordship is fashioned PIL. When a lordship wants some particular jurisdiction, lordship has that jurisdiction. Rights of the petitioner himself, who complains of infraction of such rights and approaches the court for relief. This being the position, the proper subject of our investigation would be what rights, if any, of the petitioner as a shareholder have been violated by the improved legislation. We are far away from this. He is talking about shareholder rights. We are talking about department's rights. Well, Justice Fazal Ali, this is Justice Mukherjee and Justice Kania, authored by Justice Mukherjee. Justice Fazal Ali in para 52, page 574, says this: the directness and the personalized nature are emphasized by Constitution bench in the first year of our republic. The directness and the personal nature are the two aspects I'm emphasizing. And this is held good for 75-80 years now, para 52. It has been held in a number of cases in the United States of America that no one except those whose rights are directly affected by a law can raise the question of constitutionality of that law. This principle has been very clearly stated. It is an elementary principle that in order to justify the granting of this extraordinary relief, the complainant's need of it in the absence of an adequate remedy must clearly appear. Complainant cannot succeed merely because someone else may be hurt. Only exception PI. My lord stated it. Same law otherwise here, up till now. Nor does it make any difference that other persons who may be injured are persons of the same race or occupation. On that statement of law, which I entirely agree, the scope of the discussion is greatly restricted. Justice Fazali says that. Justice S.R. Das speaks at page 595 at para 120. Fourth line, I read the whole. I read the second sentence on this. Third line. My lord has got below.
Para.
595 is page, 120 is para. Third line, your lord should turn to. After the 14th Amendment, etc. If such be the requirements of law in connection with the Equal Protection Clause, which corresponds to our Article 14, it appears to me to follow that only a person who is the owner of the property can raise the question of constitutionality under so-and-so of a law of which he is so deprived. So, of a law of which he is so deprived. If direct interest is necessary to permit a person to raise the question of constitutionality under 14, a direct interest in the property will, I apprehend, be necessary to entitle a person to challenge a law. So, two things, Malas. Himself, identity, and directness of interest. They both fuse. Then, Malas, may I try and conclude now? Malas, just summarize my principles. You should have seen enough law, Malas, here and there with the citing law. So, my solutions are, Malas, A, I'm just giving Malas points if Roshan doesn't mind. ED has no fundamental right to investigate. We are looking from all angles. So one is I have a fundamental right under Part 3 to investigate. Sorry, no. No such fundamental right has been created by our lordships in any form, in any manner, at any time. Second, its office, first is ED has no fundamental right to investigate. Second, its officers have no fundamental right to investigate.
Yes.
Three, there is no claim of a representative capacity which can arise because you are governed by statute, especially section 8 bracket 6 and 8 bracket 8 of the PMLA. This is not some kind of a civil action where order one rule 8 principle applies. It's a criminal action, investigation, no question. Fourth, ED officer theoretically as a human being can have a 21 right. I'm not saying that you are, but suppose the ED officer, not in the discharge of his statutory duty, is driving along and somebody starts beating him up, state action. Nobody is saying doesn't have a fundamental right. But an ED officer acting as an officer in this investigation, investigating her, cannot claim a separate right that which my department doesn't have the right, the statute doesn't have a right, but I have a right. That's the point I make. So don't misunderstand me. I'm not suggesting the human being can't have a right in a hypothetical case. Then, these are the 4 points. Fifth point. Parents patriae, a completely erroneous principle pressed into service. Completely and thoroughly erroneous in a criminal investigation involving Part 3 issues. Will apply only when the affected party comes through some kind of a marginalized or deprived situation. ED can hardly claim the protection of parents. It is itself the parents' patriae. As a matter of fact, there is no greater authority today in the country except ED. How can ED claim somebody else's parents' patriae? Well, I will make an aside. Don't misunderstand me. Aside. We were discussing the other day in court also that how is it possible that sensible people are having this digital arrest? I'm not talking of case X or Y. Because it is incredible.
Yes.
People we know who are otherwise normal people, who are retired management consultants, US returned senior citizens, are under digital arrest for 5 days, for 5 weeks. Which means, the wife doesn't talk to the husband doesn't talk to the wife, and they don't go out socially. This is your lordship is read in the paper every day. So, I said jokingly, it is 90% cases because terror of the caller who only cites one authority. Your lordship knows
Yes,
the telephone call doesn't cite the younger brother.
But that's not true. I'm sorry. There are maximum cases of local police.
No, very well.
Maximum cases.
Very well. Let
That's
me put
not
my
taking
example.
the political platform.
Very well. Political platform or not.
Yes.
We also read newspapers.
Fake uniform of a
There is
local
a
police.
vast difference between the terror created by the local police and when the caller says ED, and we know it, we read every day.
So in this case, who was under digital?
I said parents' patriae. And I started by saying, don't bother. Parents' patriae is the last refuge to an authority like the ED is all that I'm saying. They are considered the parents' patriae, the big boss.
There can be several parents.
Of course, that's all. I'm not suggesting this.
I spoke about who in this case is the parent.
Very well, very well. Well, as your lordship is discussing maintainability at the moment. It's not your lordship is. And then, lastly, last point. What are your prayer? You have seen the prayer many times. Prayer to CBIs to investigate. Well, where is the fundamental right for an authority like the ED asking the CBI that under my exercise of a fundamental right as a person, I can ask you, the court, to please direct. Those are my submissions. Very deeply obliged because for the accommodation. I took time in between because I was on legs. I'm deeply obliged.
In a matter like this, it happens.
Deeply obliged.
You have to accommodate.
Excuse my absence now.
I'll be
I'll be
not
As we going next.
Need to
Who appears for whom, Lord? It may not happen that one party is represented by two.
I don't know
For
why.
DGP, I said so last time when you
No,
objected.
I'm not objecting to
I'm
you.
appeared for DGP.
Because Mr. Sipal argued.
No, we have noted you appear for
Everyone argued, I don't mind, not anybody. Nothing would be added, but
He is not the gatekeeper of.
I think the part of the problem arose because the.
Anyway,
he
Lord,
did
let's
not
not
realize he made a lot of
Bengal
respondents.
here.
He made a lot of respondents.
I
Yes.
appeared for the smallest, I appeared for the smallest, I
Should have
appeared for the
waited for
DCP. So I was.
Anyway, Lord, them argued, Lord, I'm not, they're arguing. I'm only on the question of wasting time. Two people arguing for the same client may waste time, that's all.
Well, we have made lots of respondents. I'm sure we are entitled to present our case.
But I think,
Yes.
I think what my learned friend the solicitor with his usual generosity will allow us to start. With his usual generosity.
Now, may it please my lords. My lords, on the issue of maintainability, and I'll start with that before I hand over my propositions, my lords. I think it's only fitting, my lords, that lordships that when
You are waiting for
I appear for R2, my lords.
in which petition?
My lords, in the main petition. Main petition. Now, before I hand over my propositions, my lord, your lordships are confronted with a seminal case which tests